Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello everybody, and welcome to Hall & Wilcox 2024 Risk Ready Restructuring Podcast. Today we provide insights into key issues impacting the building and construction sector. My name is Mark Petrucco. I'm a partner and section leader of the firm's National Dispute Resolution Practice here at Hall & Wilcox. I'm joined by my colleague Stefan Fenk, partner in our Property and Projects team, and we're both based in Sydney. We'll be discussing the stresses experienced in the building construction industry over the recent times. Welcome, Stefan.
Hi.
Begin by just asking you a question. What have you observed in relation to the stresses experienced in the construction industry over the last 12, 18 months?
I think over the last 12 months, everyone would agree that we've probably been operating in a very difficult commercial environment. And quite uniquely, that doesn't only impact head contractors or subcontractors, but now we're seeing very uniquely stresses also impacting project owners such as developers. And it might be worthwhile to go a little bit back in time about the beginning of the COVID period, where these stresses first established themselves and really impacted the market. What we've seen through the COVID period was really an extraordinary price escalation, which really impacted the cost of projects and also the delivery of those projects for project owners. The real impact here was that at the time in Australian construction contracts, there was not a proper risk allocation for these extreme price escalations. Australian construction contracts usually would not include a rise and fall or a force majeure clause, and therefore a lot of the operators in the industry saw themselves hit with these extraordinary inflations of costs, which could not be forwarded under the contracts to the project owners. So during that time, a lot of head contractors and subcontractors were locked into lump sum contracts at a fixed price and had during the COVID period and through the price escalation to wear these additional costs. And people will recall the increases, quite substantial increases for the cost of timber, steel, and also shipping, where the construction industry in Australia is very heavily reliant on shipping and logistics from overseas materials. So in very short, the COVID period was a very stressing factor for the industry, which really saw then the start of what we have seen over the last probably 24 months, which is a very high rate of insolvencies in the construction market. And we first saw those insolvencies in the subcontractor and head contractor chain, but now we see these insolvencies are also impacting project owners. And we're really in a market now where it affects projects not coming off the ground, where developers and project owners are really looking at the uncertainty of the market. And so the insolvency risk over the last 12 months has been real and is probably going to be real for another 12 months for those very factors, starting during the COVID period of time, but then also having continued through now.
Right, so the combination of the nature of the contract, we'll talk about that soon, and the COVID period where costs escalated, materials particularly, and labour, has had this spiral effect on the detriment to the industry.
Yes, and unfortunately, those impacts have not gone away, where at the time, maybe a lot of people saw an opportunity for construction costs going down again after the increase through COVID. Unfortunately, construction costs stayed up where they were or had a very minimal reduction. And from then on, construction costs have continued to also go up and develop in the wrong direction, which increases the cost pressures on projects.
What have you experienced in relation to the impacts of insolvency, for instance, on main contractors, on construction projects?
Yes, so the biggest impact we've probably seen for insolvencies of head contractors, as those insolvencies really have a ripple effect upstream and downstream the contractor and the contract chain. What we've seen downstream is that usually when head contractors go insolvent, that comes after a prolonged period of usually not paying subcontractors. So that if a head contractor finally goes insolvent, there are a lot of outstanding debts to subcontractors, which in some scenarios has the effect of those subcontractors then also going into insolvency for not being able to crystallize the value of the work that they have provided for the project. The bigger impact even of that is then upstream to the project owner. And I think prior to this very high insolvency rate that we saw on the market, there are developers and even government entities who would have not experienced an insolvency of the head contractor and were to some extent unprepared for the various issues that result from a head contractor insolvency. And just going through some of the main impacts really is that if a head contractor goes insolvent, that usually means that the project comes to a grinding halt, which, depending on what the project is, might really have effects later down with the delivery periods and prolonging other projects to some extent as well. But the other thing is that once the head contractor is insolvent, usually a separate or new alternative head contractor will need to be obtained. And that usually happens at a higher cost than what was previously locked in with the insolvent contractor. So there are price increases for the project owner there already. The other issues are that usually the head contractor controls the subcontractors. So in a lot of scenarios, even though the subcontractors may still be around and are potentially able to complete part of the work that the head contractor has contracted with the client or the project owner, there are no real obligations between the owner and the subcontractor by way of a contract. So to get these subcontractors back on board and arrange for payment of their works, and most of the time payment of outstanding payments that the head contractor hasn't paid, it's very difficult to contractually set up. And then the very last impact of these things is usually that depending on how far the project is, if it's at a very late stage and there are, for example, defects in the project, that the head contractor would usually be liable to rectify at their own cost. That opportunity is not there anymore, especially if insolvent head contractors then go into liquidation, where they effectively cease to operate. So there are quite a few impacts on a project, upstream to the project owner as well as downstream to the subcontractors, and to unwind that very complex situation of contracts upstream and downstream can be very difficult, and it has a very impactful commercial result on all parties involved in the project.
Interesting. Now, you've mentioned insolvencies of head contractors. There are a couple of important distinctions in the types of insolvencies. Just to clarify, a company might go into voluntary administration and not liquidation. I'll talk about that separately. But if a company enters voluntary administration, the purpose behind voluntary administration is the insolvency practitioner looks at the affairs of the company and sees if it can be restructured through that process via a deed of company arrangement so as to deliver a better outcome to creditors rather than the company being placed into liquidation. So if we just pause there for one moment, Stefan, because when a company goes into voluntary administration, there are provisions in the Corporations Act which preserve existing contracts that company might have. Now, they're commonly referred to as the ipso facto provisions. So if the contract between principal and head contractor, or even with subcontractors, had an insolvency clause within it, ordinarily, using the plain language of ipso facto, meaning by the fact of itself, It would give one party the ability to unilaterally terminate the contract, except the Corporations Act prevents that enforcement right. So in a voluntary administration process, it is possible for a principal to exercise step-in rights, provided they're spelt out in the contract. And step-in rights talk about the ability of the principal to take the work out of the hands of the contractor. So it arcs back to what you were saying earlier about the principal then having to find an alternate builder or subcontractor to come in, and typically it is more expensive to complete the project in those circumstances. Have you seen instances where principals have exercised rights of step-in? And if so, what could the insolvent principal do strategically in that case so as to minimise the damage to the further damage to the insolvent company in the interest of creditors?
Yeah, and it's quite an important observation you made there, which some of project owners are not aware of, that actually the ipso facto rules prevent that very termination right. And so therefore very much still being connected to a head contractor, which might not be able to operate or progress the project anymore. So what can a head contractor in liquidation do to preserve some of the rights, or to some extent preserve the recovery of amounts to then pay debts out to their subcontractors mainly? What they can do, and what we have seen in the past, is that head contractors in administration through their administrators would reach out to the various organizations in the contractual chain and see whether specific obligations or parts of the project can be novated to the principal, therefore allowing the principal to continue with the progress of the project through the suppliers and the subcontractors that would usually be under the control of the head contractor, and therefore try to come to commercial agreements in relation to the various bank guarantees and other things that would be in play, which would be a commercial asset for the administrators.
Right. And the other aspect is, if with a successful settlement with the principal or the third party, you could arguably bring to an end the ongoing liquidated damages claim that might be otherwise available to a principal to claim against the insolvent entity.
Yeah, that's definitely an important part.
Good. What can parties do to protect themselves from engaging parties that may become insolvent down the track, or is there a little by way of protection that might be able to mitigate these risks?
Yes, and that's probably the most important considerations that project owners and developers have looked at to see whether they can incorporate into their contracts some sort of safeties in relation to the commercial and going concerns of the head contractors that they may be engaging. But even before that, some players in the market have looked at carrying out, if you like, a due diligence process over the financial capability and the ordering books of the various contractors that they had a look at, and allowed to tender for various projects. How far that goes and how much safety or security that provides, and fully understanding where the company is commercially placed, has not always heralded the result that project owners were after. Some contracts and some contract clauses that have been proposed in those circumstances was for the head contractors to provide regular financial updates, which we have seen to not be accepted very often. But some safeties in construction contracts are already there, to some extent ward off the commercial impacts of insolvent head contractors. The one that comes to mind obviously are the various bank guarantees that the head contractor provides to the project owner, which might be available to have recourse against to ward off some of the negative commercial impact through the losses and damages through head contractor insolvency. And also over the last years and since COVID, and these risks being more live in the market, various front-end lawyers have looked at also providing parent company guarantees as far as they were available, and also have started to draft into contracts clauses that provide for a follow-through from the principal directly to the subcontractor to some extent in specific circumstances, allowing a principal to pay directly the subcontractor and not the head contractor, and therefore following through the otherwise existing contractual relationship between the head contractor and the subcontractor.
They're valuable examples that contract parties should make use of to monitor the financial position of the other contracting party and the status of the project. Thank you.
That's right.
In your experience, what generally happens with an insolvent contractor?
Maybe that's a question where I can make the answer very short. And in most experiences or in most circumstances, a contractor who goes insolvent is very hard to put back into operation. One of the reasons why that is that head contractors usually don't have very many assets and are heavily dependent on the cash flow that they're earning through their various projects. So to the extent that the cash flow stops or that the cash is not there anymore to pay for the progression of projects, which then would enable the cash flow, there are very little assets available which could motivate or enable a head contractor to continuing business. And with most of the larger insolvencies that we have seen, for example, with ProBuild, those contractors effectively stopped trading and to some extent were able to sell off some of their projects to other contractors. But it's very rare, other than a full overtake or another company buying the assets, that a head contractor will be able to recover enough cash flow to start back trading again.
True. And we know that under the Building and Construction Industry Security of Payment Act, that there's a difference in the application of that piece of legislation, whether a company is in liquidation or whether it's in administration, voluntary administration, when it comes to collection of adjudications or progress claims. The legislation makes plain, it's section 32 capital B, that if a company is in liquidation, that company cannot enforce the adjudication or entertain the application itself. But courts have found in a series of recent cases that if the company, the head contractor, goes into voluntary administration and then a deed of company arrangement, it is permissible to maintain a claim under the SOPA Act because section 32 capital B specifically identifies liquidation and it doesn't talk about other means of external administration. So a court would allow an adjudication to proceed, but it might ask the head contractor to hold enforcement of payment pending any contractual right of set-off that the principal may have before determining payment of that adjudication amount. So had the company not gone into administration, if we'd been progressing the ordinary course, contractor issues their progress claim and then leads to adjudication, the principal may have a claim under a defects or a counterbalancing counter-argument to the progress claim, and the court recognises that right. But the distinction is very clear as to the impact of the type of insolvency administration that the head contractor is experiencing.
Yes, that's right, Mark. And that probably follows from the intention and the operation of the Act really providing for interim payment subject to final resolution of the underlying payment dispute. So an ability for recovery of the amounts determined by an adjudication is a basic requirement for still being able to enforce an adjudication.
Right. One final question for you, Stefan. In your view, what are the pockets of the market that have been more robust against these insolvency risks?
Yes, what we have seen is that a lot of providers in the construction industry have moved to specific areas of the market. One of the area that has continued to be strong and has provided a better environment for commercial activity has been the infrastructure basis, where there's a lot of activity at the moment, which takes out to some extent some of the capability out of other areas in the construction industry. And then we also have seen an increase in logistics and commercial and data center projects, where head contractors and subcontractors have flocked to having better commercial environments and contracts, and better commercial deals to be made. One of the markets or the areas of the market that we have seen quite a bit of a decline is unfortunately the residential market and the new build apartment buildings. That is a result of various other impacts that also influence that market, which is specifically the regulation that affects the residential market, but also a quite litigious environment for new builds of owners corporations, potentially involving developers and head contractors in a long-lasting litigation, which is very expensive. And very lastly, the property market hasn't helped any of those projects to come off the ground, where now the feasibility and the feasibility and the capability of those projects are for some of the developers not as feasible anymore as they were a result of the property market price increases and also the construction costs going up.
Sounds like most of us through COVID and post-COVID have had to pivot in our line of business. So
That's
to
right.
the construction industry. Thank you for your time, Stefan. I'd like to say thank you for everyone listening today. We hope you enjoyed the episode. As always, please get in touch with us if you have any questions. You can find our details on our website, which is hallandwilcox.com.au, or connect with us on LinkedIn. If you enjoyed today's episode, then rate, review, or subscribe to our podcasts wherever you get your podcasts. Thank you again.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.